Um, Good morning, everyone. We have quite a few people on the line, which always makes us happy. We can be of value to you. This class is being brought to you this morning by the Forum and the Becker Law Firm. And the Forum, some of you will know and some of you won't, because we've invited people from several different mailing lists, but the Forum is a group that works with HOA and condo association board members to try and help them stay on top of the latest best practices in their respective fields. We try to do these in person because we really like also the networking aspect of it. But of course, the pandemic has caused us not to be able to do that. But I am happy to say that, so we had to pivot to Zoom, and we've managed to stay keeping up with things pretty well. But I'm happy to say that the town of Juno Beach has lifted their restrictions. So our next seminar will be March 24th, and the topic will be electric car charging. So if you're interested in that, and I know a lot of people have that on their minds right now, there'll be a lot of good information that day, and I'll be sending notices out about that with the details. I want to also mention that the Forum is actually a program of the Juno Beach Civic Association, and our president, Donna Hamilton, is on the line with us today, as well as Kathy Dorn, who's a board member, and a Forum committee member, David Cox. So thanks to all of you for all the work that you put into this work that we do. Speaking of Kathy Dorn, she plays several roles, and one of them is one we couldn't do without. She sponsors many of our activities, and through her employer, South State Bank. So in a moment, I'm going to introduce her, and she will introduce our speaker, which is also an invaluable partner in our work. But before, just a few quick housekeeping details. Please keep your self muted. It will prevent background noise from occurring and interrupting. There are a few people that will be speaking. When it is your turn, unmute yourself and then mute yourself again if you wouldn't mind, for the same reason. Also, all of you, please feel free to ask questions as we move along, but understand that the questions will be answered, as many as possible will be answered by Jane towards the end. It's easier for her to go through the full presentation, and some of your questions might be answered as she goes along. But if not, we'll keep them in the chat box, and she'll answer as many as she can. So, Kathy Dorn.
Take it away. Good morning. Thank you, Kathy. As Kathy mentioned, my name is Kathy Dorn, and I'm an association relationship manager with South State Bank. South State Bank is always happy to sponsor these events. We feel like they bring very informative information to help board members better run their communities. The bank, South State Bank, has been serving associations for more than 20 years. We have a dedicated division exclusively for associations with dedicated professionals such as myself. We are the 6th largest association-specific bank in the United States, and currently have greater than $1 billion in just association deposits. Our presenter today is Jane Cornett, and it's my honor to introduce her. Jane concentrates her practice on representing condominium associations, homeowners associations, and golf course communities. She currently represents more than 325 associations in Martin, St. Lucie, Indian River, and Palm Beach counties. She handles real estate transactions and is a title agent for Attorneys Title Fund Services, and is also a certified circuit civil mediator. Ms. Cornett is one of only 190 attorneys statewide who is board certified specialist in condominium and plan development law. Ms. Cornett has twice been named a legal elite by Florida Trend, and she's involved in numerous professional and community organizations. I'm sure you'll find what she has to say today very informative and helpful. So it's my pleasure to introduce Jane. Good morning.
Good morning, and thank you, Kathy. And thanks to the other Kathy also, to the Juno Beach Civic Association for putting on this seminar this morning. As Kathy mentioned, the first Kathy, I will try to answer questions, so feel free to jot them down as we're going through. I don't typically interrupt while I'm going, because otherwise I'll never get done. I've got 65 pages of material. Fortunately, the slides are not quite that voluminous. This is a board certification class for both condo and homeowner communities. So at the end, I'll tell you how to send in your name to get your certificate, suitable for framing, of course, if you want to brag to everybody that you completed the course. If you were at the University of Florida Law School, this course would take 14 weeks. And like I said, I have 62 pages of material. So we're going to go kind of quickly over some of the things. And we may even skip some stuff because I do want to leave time for questions at the end. But I think we're ready to get going. Eric, you want to turn on our PowerPoint? They're supposed to call it a slide deck, I understand. PowerPoint is passé.
We are almost there. I just need to push a couple more buttons.
It says it wasn't going to let me do that every time I clicked it before.
Are we unable to see things right now? Is that correct?
We're not able to see it, Eric. I'm not sure why. It just says presentation has started screen sharing.
Let's try this way.
Now I'm in there.
Then I guess I'm not going to get my certification.
Well, Bill, I don't know how to fix it. You should have tried it beforehand.
It won't let you do anything until they turn it
No, I'm
on.
talking.
Could y'all mute yourself, please? We're hearing bickering.
Here's what we will do. I will,
Eric's working on it.
yes, we are having issues here.
The PowerPoint is just more interesting than staring at me the whole time. I tried to manage one of these presentations on my own once without help like Eric. And I ended up deleting everything and we had to come back another day. So,
Well, I have a backup way of doing this. If this does not function correctly. So then that's what we're going to do. Okay. Let me just switch over to something real quick here. And
we're going to start talking about what exactly is a condo or a homeowner community. And what it really is a bunch of people that are sharing stuff. In a condo, you have a lot more to share because you have the whole building typically to take care of. In case you're wondering, that's my granddaughter in the back. So very adorable child. There'll be a new one coming soon too. So a condo or a homeowner association is a group of people. Is that the first slide? Yeah. That are going to work together to operate something. In a homeowner community, it's usually less. You might have a clubhouse, a swimming pool, but you also might just have roads or drainage. Excuse me. In a condo community, you're going to have a lot of stuff that you have to share and take care of. And those are the association responsibilities. Now, in a condo, I can tell you generally what the association is responsible for. And that will be what is commonly known as the common property, the common elements. In the, excuse me, in the homeowner association, everyone is different. So I have homeowner communities where they manage. I have homeowner communities that manage a marina, a golf course, swimming pools, tennis, pickleball, everything you can think of. I have other homeowner communities where it's a few flowers at the front entrance and the roads and the drainage. So in the homeowner communities, it's all over the place. The condo community typically will have a lot of responsibilities. In both cases, whether it's the condo or an HOA, you have to look at the governing documents for that community to see exactly what the community is responsible for. For example, I have both condo and HOA communities where the developer set them up with a responsibility to take care of the roadway that is out in front, but isn't really part of their property. So you really have to look at every community, and every community is different. Now, who's in charge of carrying out these responsibilities? Well, that's the board of directors. In Florida statute 718, the condo law, that is very specifically stated. In the homeowner law, it's kind of implied, but because each entity is a corporation, then it is operated by its board of directors, because it's like any other corporation. The association can be a corporation for profit, although that's pretty rare, or it can be a corporation not for profit. Usually that's what you see, the corporation is not for profit. Not for profit doesn't mean you can't make money. You can open a hot dog stand, whether you're a condo or an HOA, and you can make all the money you want. What you can't do with that money is pay dividends to the members of the community. So in a not-for-profit condo or HOA, the property owners, the members of the community, are just like the shareholders in a traditional corporation. So you can make money for their benefit, you just can't write everybody a check. You know, in a for-profit, you can do that, although for-profits are pretty rare. So we have this corporation, it's operated by the board of directors, and condo and HOA law both say that that board of directors has a fiduciary relationship with all the members of the community. What does fiduciary mean? You are spending their money, right? The board of directors gets control over all the money that is generated by all the different property owners. And in making decisions about how to spend their money, because that's really what the board's job is, right? If you have to fix the roof or you have to pave the roads, you're going to be spending other people's money. There's a little yours in there too, but mostly you're spending other people's money to carry out that responsibility. Fiduciary relationship is defined in Florida 617, the corporation not-for-profit law. Okay, now I think you're getting an idea of why I have a job, right? Because there are so many different laws that are going to impact how the association operates. But 617 says that a fiduciary relationship means that you make decisions based upon what you reasonably believe to be in the best interest of the association. Reasonably believe to be in the best interest of the association. Okay, so you don't vote for a change in the rules because you want it or your spouse wants it. You vote for the change because you think it's good for the community. Okay, so that's fiduciary relationship. You're spending lots of other people's money and you're doing it in what you reasonably believe to be in the best interest of the association, not because of what you want. The association powers and duties, as I said a minute ago, they are different from every community. And you, in order to determine what they are, you have to look at the association documents. The law makes it clear that you have powers to operate whatever is a common property, take care of it, collect money, make people pay. Remember, that's how you get that money. You operate a budget, and we'll talk about those other factors in a minute, but you adopt a budget, you send out an assessment and people collect the money. And if they don't pay, you can make them pay. So the powers are going to be different for every community. And we'll talk about those governing documents in a minute that tell us the details of what they are. Eric will take the next slide, please. Okay, now every community, whether it's a condo or an HOA, has some level of reporting to the Department of Business and Professional Regulations. The DBPR is the Department of Business and Professional Regulations. The condo association, the developer, before he was able to sell, actually had to file the condo documents with the state of Florida, and the state decided if they complied with the law or did not. And then if they did not, he had to do it over. So every condo association has a obligation to file with the state every year and pay $4 per condo unit as an annual fee. HOAs do not have any kind of reporting directly the same as the condo does, and there's no fee, although that has been considered on several times. The homeowner association, however, does have to every year file with the Secretary of State and keep its corporation up to date. So the condo has to do both, file with the DBPR and pay $4 per unit, as well as upping its corporate entity. And the homeowner association must renew its corporate entity. The deadline for that is usually in May. And you don't want to miss that deadline because the cost of filing to preserve your corporation is much greater if you do it after the deadline. So you don't want to miss that deadline. Now, the heading that says DBPR reporting, a number of years ago, the state did require all homeowner associations in the community, in the state to file, because they just don't have information, good information about where homeowner associations are, because the developer wasn't required to file with the state. And it's impossible for them to look it up and figure out what's an HOA and what's not, because not every HOA has the word homeowner association or property owner association in its name. I have lots of clients that are called community associations, or they don't even have the term POA or HOA in their name at all. Okay, so the state required reporting, but that expired. We might see that come back again. Every year when the legislature is in session, they look at the potential for greater regulation for HOAs. Condos have a lot of regulation. HOAs only have the state involved if it's a dispute over an election, or a recall, which is like an election in reverse. So there's no state oversight of HOAs, but there has been, the topic comes up every year. This year, the legislature's in session right now. And this year, the legislature has considered by drafting a bill that would create an ombudsman position for HOAs. Condos have an ombudsman position. I always have trouble saying that. Very nice person too, a good attorney, the condo ombudsman. But there is talk of creating that position for the HOA, and the ombudsman job is basically to answer questions. That's basically the job that he fulfills, is to answer questions and try to help people understand. And he does help run elections if that is an issue. Okay. Now we were talking about the responsibilities of the condos and HOAs. And as I said, they can't always be figured out just from the fact that it's a condo or an HOA. But things that they do have in common is that just about everyone is required to have insurance. Condos, there's a statute on insurance. Homeowner associations, there are very few where their covenants don't require them to have insurance. And you want to have insurance because insurance is what protects you when something goes wrong. The documents will describe exactly what those common properties are, those common elements. The statute 718 says that condos are always responsible for maintenance of the common elements. I'm trying to remember let me look at my outline, so make sure I don't say anything really stupid. Common elements. Okay. We have two kinds of meetings in a condo and HOA. We have one required annual meeting of the members. That's required because you're a corporation. And then you have regular meetings of the board of directors to conduct the business. Okay. So there's a difference between a member meeting and a board meeting. So we're talking right this second about board meetings. The statute specifies that directors may not vote secret in the condo and HOA. Directors may not vote in secret at director meetings. And in fact, the minutes are required to reflect from director meetings who made the motion, who seconded the motion, and what the motion is, of course, and then how each director voted on that motion. Okay. So the only time the directors can vote at board meetings in secret is when you are electing the officers, the president, the vice president, the secretary, and the treasurer, and any assistants. Those votes may be done in writing, in secret, but all other director voting must be done in a public situation and reflected in the minutes. Okay. Commingling of association funds. I'm going to come to that later. I'm going to skip that for right now. Holding and noticing meetings. This is one of the responsibilities of the board of directors, to make sure that meetings are held properly. I'll come back to commingling because we'll get to accounting stuff a little bit later in the presentation. So when board meetings are held for both condos and HOAs, notice must be posted at least 48 hours in advance of that meeting. The reason for the notice is because all owners are entitled to attend, with two exceptions. If it is a meeting with the association council under attorney-client privilege, that is a closed meeting, or if it is a meeting to discuss personnel matters. Both of those meetings for board members can be held without inviting all the owners to attend. But all other board meetings where you're conducting your average business must be open to all owners, and therefore you have to post a notice at least 48 hours in advance about that there will be a board meeting. You can have a regular schedule if you want to, there's nothing wrong with that, but the 48-hour notice is required by Florida law. The condo association is also required to post an agenda to go with that notice. And the agenda must be specific enough that people can know what you're going to talk about. So it doesn't have to say contract with Harvey Wallbanger, but it does have to say contract for paving. So it's got to give enough details that owners can decide if they want to attend, because they also have a right to comment on things on the agenda. In an HOA or POA, an agenda is not required, but of course it's always a good idea to know what you're meeting for and what you're going to talk about. But an agenda is not required in an HOA. Now, I said the notice is 48 hours, but there are a couple of exceptions. If the meeting is going to talk about budgets or assessments, because they kind of go in hand, right? When you adopt the budget, there'll be an assessment that goes with it, or you might occasionally have a special assessment. If that's going to happen, budgets or assessments, you must send everybody a notice 14 days in advance of the date of the meeting, and post the notice 14 days in advance that you're going to be talking about approval of the budget or assessment, levying an assessment. So the other requirement is if you plan to adopt a rule that pertains how people can use their unit, what they can do inside their unit, then you also must send a 14-day notice. I don't see the second factor coming into play very often, I just don't see that happening for a variety of reasons. But the assessment issue, yes. And if you levy a special assessment, because you got to do some work and there's no money available at the time, and somebody doesn't pay, and you send it to me to try to collect it, the first thing I'm going to ask for is to see that 14-day notice so that I know that the assessment was properly levied. Now, if it wasn't done properly, we can go back and fix it, and it just results in a delay. Doesn't mean you can't collect it, but we have to be sure, if we're going to take collection action, that it was done right from the very beginning. In condo, posting notice on websites is a great idea. You can always use a website if you want to. In a condo of 150 units or more, a website is required, and the statute has kind of a pretty long list about what's required on that website. And if you are 150 units or more, you must post your notices on the website also. In the homeowner community, there are no website requirements, although I do see many communities using the website just because it works well. It's a good way to communicate with people. And I know there are still some folks that don't want to use computers. The vast majority do. The vast majority do. So debit cards, okay, has nothing to do with an HOA, but in a condo, debit cards are prohibited by law. You may use a credit card, but you may not have a debit card. Attorney conflict of interest. Not sure what they mean by that one, to tell you the truth. Haven't looked at it lately. Somebody else added to the PowerPoint recently, and I haven't looked at it all. The maintenance contracts. Okay. The next item, contracts with a board member. Okay. That's a conflict. That's considered a conflict of interest. It is a conflict that can be waived, however. Okay, so let's say, and this is condos, it's not HOAs technically, although you have to worry about the appearance of conflict too, which is important. There's a member of the board that has a great painting company, and you have a bid process, and his company submits the best bid. So long as he doesn't vote on the contract, if the rest of the board wants to award the contract to that director's company, they can do so. However, a vote of the unit owners can cancel that contract. Because of that cancellation provision, I'm not sure why any director would ever want to get involved with offering to be a contractor for the association. But it is not technically a conflict of interest. The law does say that directors and managers may not accept or solicit kickbacks. Of course, that's against the law. So it's always been against the law, but it was incorporated into condo law too. Kickbacks mean that you're not meeting your fiduciary duty because you're not doing something that's in the best interest of the association. You're doing something that's in your own individual for yourself, to make money for yourself. I imagine the legislature put it into the statute because there are often difficulties when there is evidence of kickback in getting the local law enforcement people involved because they're just so busy with so much else that's really high priority stuff. Not to say that condos aren't important, because they are, but most police forces or sheriff's departments I've worked with have very few people that are dedicated to what's known as white collar crime, and kickbacks are typically considered white collar crime. So it just becomes something that gets low priority in investigation. Next slide, please. Okay, and I saw a question about meetings. We're going to talk about meetings in a minute. But the question related to workshops, there's no such thing, okay? When you have a quorum of the board together and they're talking about the business of the association, even if they're making decisions or not, that's a meeting. So you can call it anything you want. You can call it a social gathering, you can call it a picnic, but if it's a quorum of the board and they're considering association business, it's a meeting, okay? Now, I mentioned a minute ago that it was owners had the right to attend meetings. They also have further rights in the law, both for condos and HOAs, for access to the official records. So both the condo and the HOA board, because that's where the buck stops, right? The board is in charge, have the responsibility to maintain records that are called the official records. And when you look at the list of official records, it's pretty much anything that comes in the door, okay? If somebody writes you a letter, you get a contract, you have a bid, anything that the association deals with, that is part of the association official records. Includes financial records, includes everything. Now, this is relevant because each unit owner has the right of access to the records. If the owner sends a written request, then within 10 business days, and the request has to be clear enough that you know what they're asking for, okay? But if they send the written request within 10 business days, the association must make those records available for the owner to inspect, okay? That doesn't mean you have to send copies out of state. So if somebody in New Jersey says, I want all the records from 1979, which you're not required to have that far back, you can tell him they can come next Tuesday to inspect the records. You are not required to send records anywhere. After the inspection, if somebody wants to make copies, they're entitled to it, and you can charge them for those copies. If they give you a list of 100 documents they want, or give them stickies so they can mark what they want, or even they can look on a computer if they want to, if they're computer savvy. You want to get them to give you the money before you give them the copies, before you go to the trouble of making the copies, okay? But they are entitled to have copies. Now, in some cases, it's just easier to send them the copies, and that's okay if the board wants to handle it that way. Keep them out of the office, free up the manager, especially if you have a lot of your records digitalized. It might be easy just to give them a stick if they're computer savvy. If they want hard copies, they're entitled to it. If they want to look at the records first, which is what they're entitled to, you do not have to have everything in hard copies. You can let them look on your computer. Although, again, you have to think about, do you want them on your computer? Somebody needs to keep an eye over that. So this, again, applies both in condos and HOAs. Now, the board can write rules concerning inspection. The board can limit the number of inspections. The board can set time periods, but those have to be official decisions by the board to create rules. Otherwise, you must respond to any request. If you do not provide the access within the 10 business days as required by the law, then the owner is presumed to have financial damage, and they can be awarded $50 a day for denial of the record access. Also true in condos and HOAs. In the condo setting, they can file a complaint with the JBCA, Department of Business and Professional Regulations, and they will enforce this provision of the law. In the HOA setting, it's not automatic. So if somebody wants to make a claim to be entitled to get paid for failure to provide access, they would have to take you to court. They would have to ask a judge to order that to happen. There again, if you have 150 units or more, then there is a whole list in the statute of what website must have, the records that must be available. Interestingly enough, in the condominium setting, the last thing on the list of items is all written records. And that has been interpreted to mean that if you happen to have like a videotape of any kind, if the association does, that is not part of the association official records and is not open to owner inspection. That sometimes comes up in the context of a video that has been made where somebody misbehaved in some fashion. Or if you have security cameras, you are not required to make the information on those security cameras available. There are other records that are not available for inspection by owners. Out-of-town addresses by owners, the local address, yes, they can get that, but not out-of-town addresses unless the owner authorizes you releasing that information. Email records, information on the emails of each owner is not available to other owners unless the owner has agreed to use email for official purposes. That does happen in some communities. Driver's license information, birth certificates, passports, anything personal that you have that would show somebody's social security number, records like that are not available to other owners. Medical records, if you might have some because somebody told you they have a condition they want you to be aware of in the case of an emergency, that's not available to other owners. So there's quite a list of things that are not, and anything obtained in connection with a sale or a lease. Those records that you've been provided, such as if you do background checks, those are not available to other owners. So if you do conduct background checks on tenants or purchasers, you need to make sure that those records in a way that they can be kept confidential. Eric, next slide, please. It is not unusual within a community that you will have a problem that cannot be resolved. For example, let's say the association has a rule that says no trucks, and somebody parks their truck on the common property, whether it's an HOA or a condo. There are a number of ways that you can address resolving that dispute. You should always first start out by trying to work with the owner, right? Because he's a neighbor, he's a resident of your community, but that doesn't always work. So sometimes you do have the opportunity or the necessity to go further. And the state of Florida encourages resolution of disputes without going to court. They offer a lot of opportunities. Now, one of the opportunities that you can take that isn't on the list is you can levy fines. The process for levying fines is something that can be difficult to achieve because not only does the board have to decide to levy the fine, there then has to be a hearing in front of a group of 3 people who are not on the board, not related to the board, not residing with the board. They have to be totally independent, but they have to be other owners, and they have to conduct a hearing to decide, yes, the fine is upheld, or no, the fine is not, and their decision is final. Now, I do have communities that use the fine process successfully, not to collect money. It's not a money maker, right? But rather, it's a opportunity to get the person to get opportunity to talk to somebody who's not on the board, because you get that us against the board mentality sometimes. So it's a way to try to work through the problem. And if it doesn't work, they may have to pay some money to get it resolved. Now, let's assume, however, that all your efforts to chat with somebody or maybe try to levy a fine against them or even suspend their right to use some of the common stuff doesn't work. Well, then you have other options. The state of Florida offers mediation. I don't know if you were listening, but I have been a certified mediator for many years. And a mediator is a person that tries to help the parties reach a voluntary resolution. So you can, and mediation in an HOA is actually the first required step before you can go to court. Okay. If the mediation doesn't work, if you don't work something out voluntarily, then the division of condominiums has an arbitration division, and the arbitration division can actually issue a decision. So the arbitration is required before you can go to court if you haven't worked things out through mediation. Okay, but arbitration, it's called non-binding because after the decision is issued by the arbitrator, either party can then go in front of a judge. What I have found over the years, however, is that most cases that are arbitrated, once the arbitrator issues a decision, everybody's done. People are willing to accept that decision. Not always, but for the most part. The decision of the arbitrator, if it's going to be appealed to a judge, the appeal must come within 30 days after the arbitrator's decision. If there is no appeal, then it becomes binding, and it can actually be enforced in a court if somebody doesn't live up to what the arbitrator ordered. But the arbitration process is designed to be used without attorneys as well as mediation. Now, many people feel more comfortable having an attorney, but it is not required. So solving problems within a community are intended to have the opportunity to be resolved without having to resort to legal assistance. The petitions for arbitration and mediation are found on the state of Florida website, the Department of Business and Professional Regulations, Division of Condominiums. And the line that says obligations of owners and occupants, well, that's, you're supposed to follow the rules. And I've often surprised when people take the position, well, those rules don't apply to me. Well, I don't know why they think that. Why do you buy in a restricted community if you're not going to comply with the restrictions? I don't. And I guess the problem is that people don't understand the restrictions before they move into the community. In the condominium setting, there are certain things that the division will investigate and can levy fines against an association. Okay, so for example, things relative to an election, again, condos, not HOAs, financial reporting and things financial, they will be investigated by the state. And any owner can file a complaint. Again, there's a form on the website. An acceptable complaint is one that they can understand. Okay, it has to be clear. And then the division will tell you whether or not it falls within their jurisdiction, their power. But as I said, financial issues, access to records, elections, those are the kinds of things that the state of Florida can investigate, and there is no charge for that, for them doing that. That's part of what they supply based on that $4 fee that's paid every year. Eric, next, please. Okay. Yeah. Yeah. In the homeowner setting, and I think I tried to say it a minute ago, but I don't know if I didn't. In a homeowner setting, you must go to mediation before you can go to court. If you're, so if you have the truck that's parked there, you must offer mediation first. And the other side typically will accept because there is a disincentive. If if I send you an offer to mediate because you park a truck on the property and we have a no truck rule, and you don't go to mediation, if we go to court later and you win, you can't recover your attorney's fees. You waive the right to attorney's fees. So mediation almost always happens in an HOA, and in many cases results in some kind of a settlement of one or another. Disputes that involve payment of assessments or tenants are not subject to pre-suit mediation. Okay, so if it has to do with removal of a tenant for some reason, or that you didn't pay money, those kinds of disputes do not go to pre-suit mediation in a homeowner association. And it's only recently that the state offered the pre-suit mediation for condos too. So it'll be interesting to see whether it starts getting used a lot by the condos because it's a new thing. Arbitration is still there, but pre-suit mediation is now an option. I just saw a question that said, do the demands for mediation usually come from the owner or the association? Usually they are from the association. I would say it's probably 3-to-1, the association starting something, maybe even higher, maybe 5-to-1. But there are cases where an owner will send a demand for pre-suit mediation. I saw one recently where the owner was unhappy with the decision of an architecture review committee, and they started, their complaint process by sending a demand for pre-suit mediation. Okay, Eric. Have I put anybody to sleep yet? This is more fun when I can do it live, because then I walk around the room and I just kind of smack people if I see that they're, drifting off. So make them pay attention. Budgets and reserves, condominiums. We'll get to HOAs in a second. As I mentioned before, the meeting at which you're going to adopt the budget, you must send a notice to everybody 14 days in advance. Okay, and there has to be an official adoption. Beginning this year, there was a new statute that said you must adopt the budget before at least 14 days before the end of the year. Okay, I'm not sure why that was put in, but there's a new provision that requires the budget be adopted before the end of the year. Now, the budget can be amended. It's not written in stone. So if you find out you've got too much money, never happens, of course, right? You can reduce the budget at a later date. You just have to send another 14-day notice. But you're supposed to have a new budget in place before the end of the year. Technically, the statute says if you don't, the old budget just stays in place. But now the new statute that was adopted that said you have to have it in place before the end of the year says if you go 2 years without adopting a budget before the end of the year, then you can be subject to a fine by the state. So that's kind of a new issue. There's 2 parts to every budget, and most people are aware of that. It's called the operating. That's where you pay your day-to-day bills that come up every year, the electric bill, the maintenance man, your beloved attorney, all the things that you incur on your regular operating budget. The operating budget, there are things in the statute that you're supposed to include in the budget. For example, the budget is supposed to include the $4 per unit fee that is due to the state of Florida. That's supposed to be a line item. The state of Florida for condos put out a very good workbook. It is called a Budget and Reserve Workbook. You can download it from the website, myflorida.com, condominiums. You can download it for free, and it really is good. It explains in great detail in clear language how to create a budget. So if it's something you haven't run into before, and you're not familiar with it, that's a great way to learn, is by looking at the budget and reserve workbook. Everything that goes into compiling the budget is part of your official records. So if somebody wants to see the information that the board examined to decide what to put in the budget, they're entitled to see that. The 115% rule has been in the law as long as I've been practicing law, which is 40 wonderful years. And what it says is, if the budget exceeds, the budget, including the reserves, exceeds 115% of the prior year's assessment, and you get a petition from 10% of the owners, then you have to call a meeting of the members. And at that meeting, the members can propose their own budget. Okay. I've never seen that done. Okay. I have seen people that said you can't increase the budget more than 115%. And that's not what the law says. The law says if you do, then, and you get that petition from 10% of the owners to call a special meeting, you call the meeting, but they have to come up with another budget. And it's just very rarely that, you know, that the owners have the ability to get that well organized and do that. I say, I've never seen it. I do know other attorneys that have had it happen, but I have never seen it happen. That's what it means by alternative budget. They have to come up with a different budget. Some of the language that's pending in the legislature right now about mandatory reserves, it's not done yet, but it looks like it's going to go through, is probably going to do a lot to negate that 115% rule. Because if the legislature makes reserves mandatory, which they seem to be inclined to do, then that's going to make a whole difference. Reserves at this time are under close examination by the legislature. The current statute says you must have reserves for roof, paving, painting, and anything that costs more than $10,000 to replace. And that number 10,000 has been there since 1992. So it's really kind of irrelevant to today's markets. But you will notice that in a condo, it is common that much of the expense is made for structural repairs. The stucco, the concrete, the rebar in the building. And those are not items that are really easy to figure out or to identify, and they're not in the list of what's required for reserves. Based on the tragedy that happened in South Florida last year, the legislature is giving serious thought to trying to come up with a way to require high-rise buildings. The current proposal is buildings that are 3 stories or more. We'll see what I said. The legislature has 2.5 more weeks, so we'll see what comes out. But the current law says the board's responsibility is to calculate what the reserves should be. But then if they don't want to fund them fully, and funding fully means that you're putting enough money in now so that when you have to do the work, there'll be enough money there to do the work. That's full funding is defined. But you can have owners waive and either fully or partially waive the funding of the reserves. Of course, the amount of the reserves impacts directly the amount everybody pays every month or every quarter, right? That's your assessment, your dues, people call them. And people want to keep that number low to the extent that they can. And so it has not been unusual for many communities to either waive, partially or fully waive reserves, just not put money aside, with the idea that when the work is needed, there would be a special assessment. One of the issues the legislature is looking at is how you decide what that fully funded number is. Remember, I just said you put in this year enough so that when you get to the time that you need it, there'll be enough there. But how do you calculate what that enough number is? Some people pull a number out of a hat because the law doesn't say how you calculate that number. Well, the legislature is talking about requiring the use of certain parties, either engineers or licensed reserve study people, to calculate those numbers. And I think we're probably going to see some changes in that aspect too. I think there's going to be some requirements that the number have professional backup for it. The number, that we're predicting we'll need 10 years from now will have some kind of professional background. There's also a proposal to require the people doing the reserve studies to have certain credentials. Right this minute, I can open a shop and say, I do reserve studies, and if you believe me, you can hire me. I would not hire me to do a reserve study. I know nothing about them. But because there are no credentials required today, there are unfortunately people that'll do cheap reserve studies for you and you'll get what you paid for, right? So the legislature is looking at that too. So the message is stay tuned. Fortunately, you probably don't have to adopt another budget until the end of this year, and we'll know a lot more about it. And my firm I'm sure will be doing seminars about the changes to the requirements on reserves. Eric, next slide, please. Yeah, I mentioned, I did say I would talk about commingling here. There are different kinds of ways to calculate reserves. I'm a really good attorney. I'm a terrible accountant. I'm not good at explaining the difference. It is explained in that workbook that I mentioned. So if you need to understand the difference between straight line and pooled reserves and the formulas to get there, take a look at that workbook or talk to your manager. Most managers understand this pretty well. I like pooled reserves, but I have other people that said they do not like them. Accountants have told me they don't like them. But I don't understand how to get to them well enough to explain everybody, but I know where to tell you to go. That workbook does explain it in good detail so that it's not hard to figure out. If you have interest on the reserve account, remember interest, we used to get that back 10 years ago or so. But if you do have interest on the reserve account, the money, that interest is supposed to stay in the reserve account unless you have a vote of the members to use it for some other purpose. The law says that it's okay to commingle operating in reserve. I do not recommend that. I think it just can lead to potential confusion because when you look at the bank balance and you see the number is larger, you might mistakenly spend money that is reserves when you shouldn't have. You have to keep accounts, paper accounts that show the difference. But since there isn't a lot of interest being paid on money in banks these days, and it's not Kathy's fault, okay, she doesn't control the interest paid at South State. But it really doesn't advantage anybody to commingle. But the law says it's okay. You can put the monies, the operating and reserve monies in the same account if you want to for investment purposes. Other reserves, you can create other reserve accounts if you think they're necessary. Those are the kinds of things that board members get to pay, the kind of decisions that board members get to make for this high paying job that they have. Of course, they're not paid at all. So, Eric, next slide, please. Okay. As I mentioned before, if you figure out that you need to put 10,000 this year into the reserve account to be fully funded 5 years from now, but you don't want to do that, then you have a vote of the membership to not do that, to waive or partially fund. That vote has to be by what's called a limited proxy, which is really an absentee ballot. So the owner gets to vote, not his proxy holder. In certain communities, you will have limited common elements that are controlled by only certain members. A good example of this is garages or carports. Okay, so some communities will have 100 units, but only 50 garages. So those are limited common elements for those 50 owners that have the garages. And they can be charged a separate fee because they have that exclusive use. Okay. And you can have expense categories that are estimates. The budget is just an estimate. Obviously, you want to try to estimate as well as you can, but the law does not say that you have to figure every category down to a nickel. So you can have a contingency fund. Sometimes that's what it's called. Okay, Eric. HOAs. Okay. HOAs are required to have a budget, but that only came into the law a few years ago. Before that, a budget was not even required. There was a lot of debate for a long time about HOA reserves. Okay. Statutory reserves and non-statutory reserves. Okay. I don't know how we got into using the term statutory, I guess because it comes from the statute, but non-statutory reserves are ones that are created by a decision of the board. And they do not have to be funded every year, and they do not have to be used for the purpose for which they were reserved. In other words, they have no restrictions on them. Boards can create them or uncreate them or use those funds at any time. Statutory reserves are ones which have been approved by a vote of the membership. So the members voted that we want a reserve account for road repaving, then that category must be included in the budget every year, and the board can't use the money for anything other than road paving. Okay, so I call them restricted and non-restricted reserve accounts. You do have to, in HOA, you do have to check your bylaws and declaration too, though, because it might be included in there that reserves are mandatory for your community. This is just what the law says. The law says if the owners didn't vote on them, then the board can do basically whatever they want to with them. If the owners did vote on them, then they are required to be funded and restricted in their use. Okay, that's in an HOA. Okay, next. Okay. Association can't function without its money, right? In both condos and HOAs, the process to collect from somebody who doesn't pay is the same. You always start out by sending them a coupon book or a notice or an invoice. You send them something, right, that says what's due. And the board should either check the documents to see when they're late, okay? Typically documents will say, if not paid by the 15th, then it's late, right? If it doesn't say in the documents, then the board should adopt a policy as to when we're gonna start collection against somebody that hasn't paid. Effective last year, the law changed and added a new notice to the collection process. That notice of late assessment must come from the association, and it cannot include any attorney's fees that have accrued to the account. So this notice has to go out that says, if you don't pay up by a certain date, and you have to give them at least 30 days, you can give them more if you want. But if you don't pay up within this 30 days, then we're going to turn it over to the attorney, and you're going to start accruing attorney's fees. You can ask the attorney to send that first notice if you want to, but if you do that, you cannot collect the attorney's fees from the owner who didn't pay. So in most cases, it makes best sense for the association or its management to send that first notice that gives them the final 30 days to pay up before they start running up attorney's fees. If they don't pay by the end, and by the way, there's a form for that letter in the statute too. So it's really easy to do. You just have to follow the form. If they don't pay then after that first notice, then you can turn it over to legal counsel to send an intent to lien letter. And that letter says, here's how much you owe, including the attorney's fees for this letter. And if you don't pay within 45 days, it's now 45 days, then the association may go ahead and file a lien. And if they still haven't paid at the end of those 45 days, then the association can file the lien and they send another letter that says, here's the lien, it's been filed. You now have a final notice that if you don't pay in 45 days, we can start the foreclosure. So there's 3 letters in 3 steps with 3 different letters in the process. It has to be strictly followed. I do not recommend you try to prepare your own lien, because if you mess it up, it can be a real problem. And the decision as to whether or not foreclose is something that every board has to make based on each case, because no 2 cases are the same. They're just different. If there's no mortgage on the property, then the association is in great shape. If there's a reverse mortgage on the property, maybe not so good. And unfortunately, there's no way to make those decisions without talking to your attorney. That's what has to happen after that last 45 days is up. No attorney will ever just go ahead and file a lawsuit. They will discuss it with you, with the board, as to what the options are, what's the downside, what's the upside, what you might expect, what you shouldn't expect. And then you will make a decision as to whether or not to foreclose. Foreclose is a lawsuit that can result in the owner losing ownership of that property if he doesn't pay at some point in the process. Next slide, please, Eric. Okay, condo elections. We've been doing this since 1992. That's when the law went in that requires the process that is used. And HOAs listen to this too, I recommend, because when I'm asked to amend bylaws for HOAs, I recommend that you consider a process like this because it works. So when you're ready to elect the board, remember these are the folks going to spend all the money, right? Run the place. You start out first by sending a notice to everybody 60 days in advance of the date of the election that says, hey, who wants to be on the board? Send in this form, turn in your intent to run, notice of intent, it's down there on the list, right? And you will be a candidate unless you violate the statute, which says you cannot serve on the board for more than 8 consecutive years. The term of office is limited to 8 consecutive years, unless nobody else wants the job, which is not uncommon, right? Election is often our time for begging, please run for the board, right? Or you get approval of 2/3 of all the owners, okay? So the first notice goes out that says, in 60 days, we're going to have an election, and anybody who's interested in running, please send in your notice of intent to run. Anybody who is 90 days delinquent in payment of anything, any assessment to the association, cannot be a candidate. Okay, so, or if you've been convicted of a felony, you can't be a candidate. The thing about convicted felons is they don't always tell the truth. So you may or may not know whether people are running. But what I do is on my intent to run form, I put those restrictions, you know, that you can't be in arrears and you can't be a felon. I put it right on the intent form to at least remind people. Okay, so they return these intents, and then 40 days before they must return their intent at least 40 days before. And then they can also put in a page that describes their qualifications. The association is not responsible if they put slanderous statements in there, but you can't alter what they write either. So whatever they put in, you have to send out. If you only have 3 openings and you only have 3 candidates, after the 40 days are up, then you're done. You don't have to have an election. When you get to the annual meeting, those folks just automatically take over. If you have more candidates than you have openings, then you have to send everybody a ballot. The ballot, I'm realizing we left words off there. The ballot will list all the names in alphabetic order, and the mailing will also include the candidate information that they have provided. The ballot can be voted either electronically, or people fill out the ballot, put it in a ballot envelope. That ballot envelope goes inside an outside envelope, and the outside envelope gets your identification on it, so that once they verify that you've only voted once, and then they separate the ballot and the outside envelope, it's a secret ballot. And that's, I think, why people like the process, because then nobody is able to figure out how you voted, and that makes people comfortable. If somebody has a handicap and they need help filling out the ballot, they may request that. But you definitely cannot have a forgery of a ballot. And that is an issue that the state can address, and with fining the person that's guilty. I've heard people claim that there was forgery, but I've never seen anywhere where it was something that could really be proven. It's just difficult. Let's see the next slide, please. I probably need to pick up speed a little bit, so we have time for some questions. Oh, yeah, you have it. The ballots have to be kept in a secure location once they're received. If you're going to open the ballots, you have an impartial committee who will do the opening and the tallying. The committee must be people who are not related to the board, not running for the board, not candidates. They have to be totally impartial. The board is supposed to appoint that committee in advance of the actual time of the election. The people with the most votes win. In condos, if you only have 20% of the people vote, that is an election. Okay, hopefully more will vote, but you only need 20% to constitute a valid election. If there is a tie, the 2 people tied are entitled to have a runoff, or they can decide to flip a coin. It's really up to them. But they're entitled to have a runoff to be done if they wish to. In small condos, 10 units or less, you can adopt a different procedure for elections. Okay, but you must, but that has to be done as an amendment to your bylaws. I have had communities that use voting machines. You can hire them from the local elections office, and some people like that. You're not supposed to have somebody else assisting unless they're in casting your vote, unless you have some sort of disability that requires it. And Florida law requires, both for condos and for HOAs, that within 90 days of the date of your election, you must either attend a class like this, a board certification class, or sign a certificate that says you've read everything and understand everything. We call that the liar's certificate, but it is an option if you don't want to attend the class. There is proposed legislation right now that, if passed and approved by the governor, will require people to do both. The proposed legislation requires the class and sign the certificate. I don't know how many classes there will be available, because there's a lot of board members elected every year. But I guess we'll see what happens next. Next slide, please, Eric. In a homeowner, Depends on what your bylaws say. Okay. Everything is going to be covered in your bylaws. The bylaw, and I'm not talking about the declaration, I'm talking about the document titled bylaws that says when your meeting will happen. But everything about that will be covered in your bylaws. If it's not there, which sometimes that happens, then I recommend the board adopt the procedure and tell everybody in advance. Okay. The law does say if you have a way for people to self-nominate before the meeting, then you don't have to allow nominations from the floor. And so that's why when I'm asked what to use, I recommend the condo process because it usually results in getting people to vote. But the law only says that everybody can run, everybody who's an owner in the community can run if they want to. But it doesn't specify how you do the election and nominations or anything else. It does require the board's certification. Okay, so you got to look at your bylaws to know what it is for your community. And if the bylaws don't say, then we should be proposing an amendment to the bylaws to make it clear. But in the meantime, the board should adopt a policy and tell everybody what it is. You know, that's the whole idea. People are happy to play by the rules in most cases, so long as they know what the rules are. Okay, Eric, what's next? Okay, this is actually true for condos and HOAs. A year-end financial report is required based upon the money from the prior year. And of course, you could be in a fiscal year, you know, it doesn't have to be a December 31st year end. But for condos and HOAs, you are required to have a year-end financial report prepared, and it's supposed to be done basically within 90 days of the end of whatever your financial year is. Who prepares it is going to depend upon the kind of report. I think the kind of report is on the next slide, so we'll talk about it. But it'll be based upon the annual money that came in the door, the annual revenues, okay? So when we see what's required based upon the money that comes in, the reason I mention that is because what sometimes happens is you'll have insurance recovery, and that's part of the annual revenues. So if that kicks you up into a different financial reporting category, you have to be aware of that. You might not have planned for it because you didn't know you were going to get money in August from an insurance recovery. Let's try the next slide, Eric, please. Okay. If your annual income, your revenue, the money that came in the door was less than $150,000, you're a small community, you don't have a lot of expenses, and you report your taxes on what's called a cash basis, not accrual, then you just have to show people the money that came in and what you spent it on, the revenue and the expenses. So that's called a report of cash receipts and disbursements. Okay, so small communities, that's all you're required to do. And that can be prepared by anybody who can count, right? Does not require any kind of professional assistance. Okay, next slide, Eric. If you have more than 150, I'm looking for my notes too, then you must do your reports on what is called an accrual basis, which is different than cash. And it has to be prepared in accordance with generally accepted accounting principles. This is in both condo and HOA law. Okay, next slide, please. Looking to see if I can. So there's 3 levels, and that's what I'm looking for is the numbers. I thought they were on. I'll be right back. I'm not far. I'm just looking for the numbers, so I say them right. The good news is we're getting close to the end. Okay, so we just mentioned for 150 and under, it's a cash basis. If you have more than 150,000 income, up to 299,000, that is a compilation. Okay. I've seen compilations prepared by management companies. There is no requirement that they be done by an accounting firm, but in many cases, people feel comfortable having it done by an accounting firm because it's another set of eyes that take a look at the financial statements. Okay. If the revenue is 300,000 to 499.99, then it is a review. Now, a review must be prepared by a CPA. Okay, the CPA actually expresses opinions in the review, so that's required to be done by a certified public accountant. If you have $500,000 or more, then an audit is required, and an audit also must be prepared by a CPA. And of course, it does a much more in-depth examination of what they even look at things like your documents to see if you're in compliance with your documents, and they'll comment on things like reserves and such. Okay, so it's the financial status of your community, the money that comes in the door, will determine the kind of financial statement that you're going to have. The members can vote to waive an audit if you have, large community, a lot of money. But if you're going to have, or a review or a compilation, they can vote for a lesser standard for the financial report. But if you're going to do that, it has to be done in advance of the time that the audit is going to be prepared. So if you wanted to waive the audit for 2021, you had to have that vote in 2021. Once you get to 2022, it's too late. You have to have that vote in advance. If you're serving on a board and an audit is required, I recommend that you not ask to waive it. You're only going to save a few bucks, and there is nothing that is better protection for the board members than to have a clean audit that shows that there was no financial hanky-panky of any kind. Because the quickest way for a board member to get in trouble is for somebody to claim, whether it's valid or not, but to make a claim that you did something wrong with the money, right? We started this whole conversation out by saying you've got a lot of their money and you get to spend it. And there is no greater way, no easier way for an owner to make a complaint is if it has something to do with the money. So directors serve for free. The cost of an audit is not phenomenal. It is, if you have a budget of $500,000 or more, it is a drop in the bucket, compared to the other expenses. So it is not something, and I don't think it's in the best interest of the association not to have the audit. Because if something was done improperly, don't you want to know about it? So the audit and the review, I do not recommend that they be waived. The compilation and the cash flow, they're not that big a deal. People want to know the money, but we're not talking about huge bucks there. But when we're talking about audit and review, yes. And it's the kind of thing that could lead to invalid claims, okay? Because that's what people, people get these ideas in their heads, and they're hard to dissuade unless you have something like a nice clean audit to show them. What's next, Eric? Oh, this is some of the details. The best thing I can tell you about audits, reviews, compilations is hire an accounting firm that has experience with condos and HOAs, because your financial statements are different. They are not the same as the average corporation. These are the things that the statement must include. And so if you want to, compare, you can take this list and compare it to your financial statements, make sure that you're getting good ones. But these, so the audits and reviews are different than for other corporations. So you really want to have a company that's had experience. And there's lots of good ones out there. There's lots of very good CPA firms, accounting firms that can give you good financial statements at a reasonable price. And don't hesitate to ask about the price or negotiate over it. That's you're doing business just like anything else with them. Okay, Eric, what's next? Okay, this is for HOAs alone, so condos can not listen for a minute if you want to. And before I forget, in order to get your certificate, what you need to do is send an email to my assistant, Tammy. Her email is tgale, so Tammy Gale, tgale@beckerlawyers.com. So tgale@beckerlawyers.com, and put that it is about course 0016, and include your full name as you want it to appear on the certificate. And then a couple of days, Tammy will send you back a certificate with your name on it. You're supposed to provide that to the association secretary. Okay, these become part of the official records and they're supposed to be retained. Okay, so tgale, G-A-L-E, tgale@beckerlawyers, BECKERLAWYERS.com, tgale@beckerlawyers.com, course number 0016, and she'll send you a certificate. If anybody happens to have a management license, I didn't see anybody that I thought did, but if you do, include your management license number, and you can get CEU credit for this class too. So if you have a license of some kind. Okay, MARTA, the Marketable Record Title Act. The Marketable Record Title Act was actually adopted back in the 50s. And it was adopted in the 50s because we had terrible records of transfers in Florida. Up until, I'd say the 70s, late 70s, records were kept by hand. And they weren't particularly good. And in the 60s and 70s, when we really started selling property here, and all the Yankees started coming in, buying it by the bucketful, right? The title industry started up. The title insurance industry didn't exist before that. When you bought property, you got a stack of documents that were your title search. Okay. But the problem was there were all kinds of messy documents out there in the public records, and the public records weren't very good. So the title insurance industry talked the legislature into adopting MARTA, the Marketable Record Title Act. And what MARTA says is, if you have a document in the public records and there's been no activity on that document for a period of 30 years or more, but 30 years was the magic cutoff, then that document can be considered dead. It doesn't have to be considered for title purposes. It doesn't exist anymore. Unfortunately, when the act was adopted in the 50s, we didn't have homeowner associations. And this does not apply to condos. This only applies to homeowner and property owner and community owner associations. Okay. And so what we discovered after a while was that the Declaration of Covenants, which is what says what all the responsibilities are for the community were being killed off by MARTA. It was an unintended consequence. So the legislature said, oops, we didn't mean to do that. That wasn't what we meant to wipe out. We were just kind of trying to get nice, clean records so that we could sell property without worrying about these claims in the past. Because you would have what they call wild deeds. People would just sign a deed to property they didn't own and they'd record it. So they created two methods to deal with covenants for communities that might have died or were going to die. The first is called preservation. So a homeowner community, by action of the board, no vote of the membership, just an action of the board, before the 30 years are up, can record a notice, and it's called a notice of preservation. And this notice says, hey, our documents were recorded 29 years ago. We don't want them to die off. Here's the notice that says we're preserving them. And that's all you have to do. Unfortunately, covenants had died before people knew about it. The 30 years had already run. And calculating the 30 years is actually kind of complicated because there's something called a rooted title. And it's really convoluted. So, but the 30 years was up, the covenants were dead, the corporation still exists, right? The HOA is still there, but it had no powers because it didn't have any covenants. It didn't have any easements or restrictions to enforce. So in that case, there is a process called revitalization to bring life back into those covenants. And so if a majority of the owners in the community sign the appropriate document, and there's a proper form and everything, and then it gets shipped to Tallahassee, there's an organization, a government entity that has to review it and make sure everything's okie dokie. But then after they issue their approval, then those old covenants get re-recorded along with the notice from the state that they've been approved, and the covenants are revitalized. And you're back in business, cutting the flowers and trimming the grass and all the kinds of things that you've been doing. So that's the MARTA for homeowner associations only. It doesn't affect condos because when you look at your deed to your condo, it says unit 14 as per the declaration of condominium as recorded at such and such, and that overcomes MARTA because of the way deeds are written in condos, but deeds in HOAs, they're not typically written that way. I have had communities where the developer attorney was really smart and wrote the deeds so MARTA doesn't wipe them out, which is very nice. But that's not common, that especially communities that are more than 30 years ago, because this wasn't quite so well known 30 years ago. The legislature adopted a provision last year that said, if you record an amendment, that will also serve to avoid MARTA. That's kind of new, and I'm not real sure how it's going to work. So if my client is getting close to 30 years, I recommend they do the preservation notice anyway, just to be on the safe side. It's really cheap. It's not a big expense to do. So I'm still doing preservation notices. I'm not relying on amendments because they say that provision only came into the law just about 1.5 years ago, and I'm not real sure about it. Eric, are we done? I think this is the last slide. Let's see if we can do some of these questions. Let me call them up here. Let me see. Let me go back and see if I can pick up some of these. Comment on notice to enter units when there is not an emergency. This would be a condo. Okay. Florida statute 718-111 says that an association has the right of access, reasonable right of access to a unit when necessary to protect other units or the common elements. If it's an emergency, the water is running, I think everybody understands, you can open the door and go in and shut off the water or whatever is necessary. If it is not an emergency, then the owner must be given reasonable notice that they're gonna need to come in. They need to make reasonable efforts to coordinate with the owner if the owner wants to do that, or if there's a tenant, something like that. The question said, comment that it's not unfettered access, and that's correct. It is not unfettered. The owner is entitled to get notice before, and the access, unless it's an emergency, needs to be during regular business hours. You know, if you're going to show up at 10 o'clock at night, something needs to be on fire or, you know, flooding. Unfortunately, as our condo buildings do get older, we do have more and more problems with water pipes breaking and stuff like that. So the access is absolutely necessary. But yes, owners are entitled to notice. Must official minutes have the name of the person who prepared the minutes? You know, that's an interesting question. Let me repeat it again. I wasn't clear. Must official minutes have the name of the person who prepared the minutes? There is nothing in the statute that tells us that. The minutes for a members meeting, which typically, not a board meeting, right? Typically will be the annual meeting of the members, are required to be provided by the secretary under Robert's rules, if Robert's rules control your community. But not every community is controlled by Robert's rules. You have to look in your bylaws to see if that's true. Robert's rules do not control in boards of under 12, okay? So small group board meetings are not intended, and it says this in Robert's rules. It says, don't apply to small board meetings, technicalities. And of course, that's things like the president can make motions, the president votes, is required to vote, which is not the same at large group meetings. But there is nothing in the law that says that the preparer of the minutes has to indicate who they are in any way. You know, if you have a management company, let them be of assistance. Now, your bylaws might say the secretary is responsible for preparing minutes, but that would be your bylaws. There's nothing in the law about that. And I have had people ask that before. So there was the question about what's a workshop. There's no such thing as a workshop. Anytime you have a quorum of the board, I mean, you can call it a workshop, you know, to gather information, but it's still a board meeting. If you have a quorum of the board and they are thinking about, considering, discussing the community business, whether it's condo or HOA, it applies in both cases, then it is a board meeting and it has to be open to owners. And if there are motions, you keep minutes, but you know, if you're not deciding anything, you don't have any minutes. You just say, we all met and we listened. But there's just no, board members in both condos and HOAs are permitted to communicate with each other by email. They are not permitted to make decisions, but they can, you know, circulate the painting contract and everybody comment on it, so that when they get to the meeting, they're prepared to make a decision. But there's just, you know, you got a quorum, you got a meeting. Can a pair of spouses be on the board of directors? In condominiums, the spouses may not serve on the board at the same time unless they own more than one unit or there are no other candidates. So if there's no other candidates, then they can both serve on the board, or if they own more than one unit, then they can have as many potential people serving on the board as they own units. What is the vote when a director abstains from voting on the condo issue? You have 5 directors. One of the directors abstains, and you're not supposed to abstain because you don't want to publicly say your position on an unpopular topic. You're supposed to abstain if you have a conflict of interest. Your job is to make decisions. You're not there to duck the hard questions, okay? But let's assume that they're voting on a contract with your company, so you have a conflict of interest. The vote is still the same. You're there, there's 5 people on the board, so they still need a majority, 3 to approve the decision. It doesn't change. That might be more relevant if you have a larger board. Posting notice on the website. The same notice that you would put on the condo property, says there's a board meeting at 7 p.m. on Thursday, is the notice that you have to put on the website also, if you have more than 150 units. If you have less units, then you're not required to do anything with a website. Do the petitions for mediation, I answered that one before. They usually come from boards. Is there a standard definition of the scope that a rule can address? What can rules address? Okay. In both condos and HOAs, the power of the board to adopt rules depends on what the documents say. So you have to start by looking at the declaration first. What does it say about the board's power to make rules? If the board has the power to make rules about the whole place, then they have the power to make rules about the whole place. If they only have power to make rules about the common elements, then they can't make a rule that says you can't have purple curtains. Okay, so you have to look at the declaration. There is no statutory decision about what is a rule. A rule, once you decide what the power is, a rule cannot contradict or contravene the terms of the declaration. That's language from a case. So the declaration says owners may have pets subject to the rules adopted by the board. The board cannot adopt a rule that says no pets, because the declaration says owners can have pets. The board can adopt a rule that says no more than 2 pets per unit. The pets have to be walked in a certain, they can adopt rules about those pets, but they can't prohibit them, okay? So the rule has to be reasonable, and it can't contradict something that's already in the declaration. Reasonable, that depends on every different community and the facts today. What was reasonable last year may not be reasonable this year. It has to be considered in the context of what's going on. So, it would be nice to have things very clear, but they never are, okay? But a board almost always has the power to make rules about the common property, the pool, the clubhouse, the barbecue, but restrictions about the color of the drapes in your window, that must be authorized in the declaration. What information must be included in the statement of account invoice as pertains to unit owner? Well, they need to know what they have to pay and when they have to pay it. Things should be clear, right? That should always be the goal. My advice to clients is always use as few words as possible and be as clear as possible. So they need to know how much they owe and when they have to pay it. If there's itemization, if you're charged for more than one thing, as in some community, then the charges should be itemized. But in most communities, you're going to get a notice that says you have to pay $625 by January 1st, and here's where you send it. And that's typically what you're going to see. Again, it's the kind of thing that could vary from community to community. Does the statute or common law make any distinction between residential and purely commercial? Yeah, the 718, much of 718 does not apply to a strictly commercial condo. So if everybody in the condominium is commercial, they're not required to attend this course. The election process does not apply. So there's a lot of 718 that applies only to residential. It gets kind of questionable when you have both residential and commercial. So, the first floor of the building is a restaurant. and the second floor is shops, and then the rest of the floors are residential. There's ratios in the statute. But most of this, much of the statute, I shouldn't say most, much of the statute, most of what we talked about today does not apply to a commercial condo. They have a lot more latitude in what they do. Do directors who have been on the board previous year have to recertify? No, you do not have to recertify so long as you stay on the board. If you leave the board and come back, then you're supposed to recertify. I recommend you take the class 5 times anyway. Educational research says you remember 20% of what you hear and see. So that means it takes you 5 times to get it all. Okay, it's T Gale. Eric, you posted T Yale, it's Yale. Okay, for the email address is.
Yes, I went back and I made a correction. I
Did
typed
you?
in
Okay, good.
correction very large. So
Okay, good. Yeah, it's
yeah, T
Gale.
Gal.
And it doesn't have to be capitalized. It's fine. But yeah, we need your full name or the name you want to be called by on your certificate. How can board members meet during the month to discuss project or work or get the, they can't. We live in a state where sunshine law prevails everywhere. And if you have a quorum of the board together, then it's a board meeting. If you want to meet without opening it to owners, you have to make it less than a quorum. So if you have a special project, appoint 2 directors to be in charge of that project and let them check up on it every day. I have had communities where they had major projects ongoing and they posted a notice that said there'll be a board meeting every morning at 9 o'clock to inspect the ongoing project. And the first couple of days, a few people showed up, and then after that, they got tired of it pretty quickly. But the law does not allow the board to get a quorum together on the phone, on Zoom, in person, without inviting everybody else. Regarding condo, website should be for, I should read the question, sorry. Regarding a condo association website, I assume the website should be for homeowners only and not open to the public. Is that correct? It is intended to be for the owners. That is correct. Some communities have a section of the website that is available only, that is available to other people who are not owners. But yes, this website does need to be password protected, and you absolutely have to make sure that any financial information is not able to be accessed by anybody who is not on, not an owner and eligible to be part of the website. You mentioned 20% of condo owners required for an election. What is the percentage for an HOA election? Good question. In an HOA election, it will depend upon your bylaws. However, Florida statute 720 says, and has for quite a few years, that the quorum for a member meeting is 30%, 30% of the members, unless your bylaws provide for a lower number. So usually the election, again, every set of bylaws can be different, but usually the election will say that you have to have a quorum, so that'll be 30% or less. And then of that quorum, the people that get the most votes will be elected. But you do need to check your bylaws to make sure that that is correct. Because the bylaws can't say more than 30%, but they could say other things about what the vote is required to get elected. How do you replace a board member who resigns? Unless the bylaws say something else, which they could, then the remaining board members will have the ability to appoint someone to fill that position for the remainder of whatever the term is. But again, you have to check the bylaws because they could say something else. What about service dogs? That is a 2-hour seminar in and of itself. The first hour was given recently, and if you want to look on the firm website, you'll be able to find it. Joanne Burnett was one of the attorneys involved. I remember that. So if you look for, but I'm pretty sure they posted the video, and there is another hour coming up on that. So that is a very complicated topic, and nothing I can answer in this time frame. If a board determines a professional reserve study is required, does it have to be approved by the residents or just the board? Just the board. I've never seen a case where, remember, the board makes decisions, the board gets stuff done. The unit owners elect the board. There's a few cases where they are required, they are entitled to vote, but it's very few. So that's an operational decision to get a reserve study, and the board puts it in the budget. They gotta pay for it too, of course. Condo rules pertaining to limited common elements such as porches. I'm sorry, I should read the whole question. Condo rules pertaining to limited common elements such as porches, which is an extension of the apartment. Must the board notice all owners 14 days in advance with the proposed rule? If it's limited common element, no, the statute does not require a 14-day. Even though it looks like an extension of the unit, it's not the unit if it's a limited common element. You have to look at your declaration to decide whether it really is part of the unit or part of the limited common elements, but the statute does not require 14-day notice for rules on limited common elements. Can a board member be held responsible, liable for being negligent and abusing their power as a board member? I can't define abusing power because that's just way too broad. If they're not a nice person, then you take them off the board. If they're not behaving well, you take them off the board. Florida law currently says that negligence alone is not a basis for a claim against a director who's working for free. Okay, so the real recourse, if you have a board member who's not doing what he should be, is either don't elect him next year or take him off the board in the process for recall. Regarding this statute, do renters have the same rights as owners? Maybe, depends on what the declaration says. The declaration can distinguish between renters and owners. The case on this was called Woodside, and it's about 10 years ago, I think. And what the Florida Supreme Court said was, if the membership in the community want the restriction and it's not illegal, okay, then it will be approved. So if it's approved by the members, then it can be discriminatory against tenants. That's life in the big condo, folks. It's a majority rule or whatever provision it says for amendments. This is a first. I got through all the questions. That doesn't usually happen. So I'm glad we were able to do that. And I'm glad you all could attend today. Kathy, you got any parting words of wisdom for anyone?
Yeah. Hi, sorry. I was just trying to get off unmute.
Jane, thank you so much. I mean, you're amazing. This was a very informative, clear presentation, and I'm sure that has benefited all of you that are here with us today, most of whom are probably new board members, and hopefully this will get you off to a really good start. And I thank all of you for attending as well. Thank Eric for being our technical engineer and getting us through it. But I thank all of you for coming because you are serving in the roles as board members because you care about your communities. And there's no better way to learn than through some of these seminars. And I'll be following up with you to give you some information on the forum for those of you who don't have it, to see if you want to be on our mailing list on a more permanent basis. And thank you very much. Have a great rest of your day.